Hello everyone, welcome back to another episode of the Darrell Brooks saga. In today's episode we're gonna finish pre-trial. We are actually just we're gonna be done with pre-trial and we're gonna be straight up into trial on the tomorrow's episode. But for now, I just wanna say thank you guys for watching. Thank you for liking the video, thank you for subscribing. Thank you for all the love that you show to me. It's really incredible, and I can never thank you guys enough. Just remember, you guys are here. You matter. You're great, and I'm glad. And I'm glad that you're still here with us. All right, let's get into the video.
Nothing else from the state, Your Honor.
Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
Yeah, I'm still, I don't understand how any questions that I was asking are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony?
Thank you, Kim Jack Riley, for subscribing. I need to thank you. That caught me off guard, but thank you for subscribing. Do the same as Kim. Subscribe to the channel.
Or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022.
Yeah, I would like to, is it a way that we can verify the standards of the Keep Separate Protocol?
Mr. Brooks?
To be able to show
Mr. Brooks, please listen very carefully. There's a question I'm asking you is, do you have any other evidence? Document? All right, then I'll.
Can't even answer.
All right, I'm going to mute him once again. He is not.
Again, he thinks that she needs to answer his questions, and I don't know why. I don't know why someone needs to tell him what to do or what to say, or that's why you have a lawyer, and that's why he had two lawyers at the beginning.
Not answering very clear questions.
He also has no idea what an objection is.
Mr. Brooks is holding up the objection. We're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I stated pretty clear why it should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's
See, this is the problem. She's asking you, like, I'm about to rule on this. Do you have something that will help me decide? And he's like, nah, just remember what I said.
it's clear to me that the wrong person was testifying.
And again, when he always says, it's clear to me. Yeah, because you're thinking of it. But the other people are not in your head. So how are they going to know about it?
She said that she was not present for the said COVID test. To her knowledge, no way to say for sure why I wasn't provided with the test that I should have been provided with if that becomes an issue.
You were provided.
Honestly, Your Honor, I'm powering my way through this hearing. I feel like total crap, to be honest with you. I don't feel good at all. My reason for raising this issue, like I said, was strictly a health and safety thing. It didn't have anything to do with trial prep. It didn't have anything to do with access to anything. It was strictly.
Then why were we talking about all of that before with the JA? You were even asking about showers and shaving. I don't get it.
Because, like I stated before on record, I've never had this issue come up for me. Like I stated before on the record, I've had people that I know, loved ones, close people, pass away from this COVID disease. Frankly, I'm terrified because I have yet to even get the results back to say whether I'm positive or negative. I am fully vaccinated.
And then he contradicts himself. Like, I'm terrified because I don't know the results. When the judge was like, I can give you a rapid test right now. Will you take it? He's like, nah.
I've never tested positive for COVID. And frankly, to even be told that it's a possibility that I could have COVID, it makes me very afraid. And my intention was to at least be able to get the results back so that I know, okay, I'm good to go. Let's keep the ball rolling. That was my intention. And not wanting to infect anyone else or put anyone else in jeopardy. And also doing the things that I may need to do if I'm found to be positive, doing the things that I need to do to be healthy. That was my concern, and that's why I raised the issue, Your Honor.
There's nothing extra that you need to do. Like, at that point, it will be just resting and eating and... I mean, what do you need to do if your results are positive?
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. So I would ask you to deny the motion to adjourn because of the COVID protocol, and to the extent that there was a prior motion to adjourn because of a keep separate order, that also is inappropriate at this time. Thank you.
Who is he trying to get a hold of that he needs to call 17 times? In the morning.
Thank you.
Your Honor, may I state something for the record?
You may briefly respond. Go ahead.
One of the detectives that is sitting right behind the prosecutor's desk right now, Detective Casey, just went through something similar with COVID and was not present for a couple of hearings. I don't know how long.
Who cares about him? He's free. He's a free man. He can do what he wants.
His protocol was. I can't speak to that situation. It's not my business, frankly. But he wasn't present in the courtroom, and I think that has relevancy due to probably him feeling the same way, not wanting to infect.
It has no relevancy whatever Mr. Casey does against you, that you have a trial coming up literally tomorrow.
Anyone else or put anyone else at risk. I don't see where there's any difference in my situation.
I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. He has full access even with this protocol. He has had access even to the phone. He would not answer the court's question directly about whether he would take a rapid test. To me, his credibility is at issue with that. If he were truly concerned about his own health and safety, he would want to know immediately, and he repeatedly would not answer that question and instead wanted to debate about what test was provided to him and why perhaps it was not. All right, you're interrupting me. I'm going to mute you.
How is that not accurate? That's what happened. She offered you a rapid test and you were like, nah, I don't want to take another test because I already took one. Like, if you're really scared, you would be like, yes, do it. Let's do it right now.
So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic, given the information that this court, and once again, on the record before me, there is nothing to suggest that he is actively being impacted by COVID-19. I know Mr. Brooks appears to be talking to someone and hand gesturing. Unless he writes a note that he has a topic he wants to address for me at this moment, I'm going to assume he's just directing his commentary to the bailiff that's in there. I will unmute him momentarily to ask him a question, and that question is whether there are any housekeeping issues on his list. All right, Mr. Brooks, are there any additional issues that you believe need to be addressed? Mr. Brooks, can you hear me?
He can.
Mr. Brooks? Do you have any additional issues to what I've already set forth and the state's added to the list of what I will call generally housekeeping issues, other than perhaps the motion for reconsideration? That's not housekeeping, but.
I was having a side conversation with the bailiff about something, so I didn't hear the last part of what you said.
It's my understanding that the bailiffs would not be having a conversation back with you or at you during court proceedings, so I'll have to confirm or deny that with them. Becky, if you could talk to the bailiff, please.
I love this. Like, look at this face. Look at the way that he's looking at the judge right now. Like, he tried to be sneaky. He tried to be like, I'm ignoring you. So can you repeat that again? And she's like, I'll see if you really were having a conversation with them. I can ask them. And he's like, oh, she got me again. My lies are still being discovered. He doesn't understand that he's not in control, and that they're not gonna take what he says on his face because he already lied so many times. So they're gonna fact check everything that he says.
He was asking how to pronounce a word.
All right, so it's my understanding you were asking the deputy how to pronounce a word. Did he provide a response back to you, Mr. Brooks?
A kind of a response.
Yes or
What do you mean
no?
by that?
It was kind of a response.
Did he provide a response verbally?
Yes. No.
I'd rather not say R&B.
Then why say you were having a conversation with him? Like, you set yourself up for this position.
I'll have to get clarification from the bailiff later on.
He's coming in.
He's coming in here. Okay, thank you.
He asked me to pronounce what the pronunciation of a word was, and he spelled it to me. I said, I don't know what that is.
Okay, thank you. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
That's
My
not a-
question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
How hard is to say yes or no? She always does this. She's like, I have a yes or no question for you. Can you answer it? And she's like, oh, tomorrow was Sunday. And the judge is like, that's not what I asked.
I will ask one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom.
So if the record reflect that I did not respond, I responded, it just wasn't accepted.
The record speaks for itself, sir.
Your Honor, I'm very tired, so.
Mr. Brooks, we're gonna keep going. So please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
I was just really trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that by sworn
Mr. Brooks, I'm
affidavit
gonna
that I
mute you.
cannot
Okay.
What do you mean verify that? She's telling you. And that's something that he doesn't understand. Everything that she tells you is because she knows. Like, the judge is not gonna say something that she doesn't know. So when she tells you that's not something for her, because an appeal is, she doesn't appeal your decision, your case. Someone else does. That's how appeals work, and you're never gonna win one.
Okay, Mr. Brooks, you've now earned the mute button once again. You have a total number of convictions for Mr. Brooks, and the number that you would ask be the number he answered the question to. Should he testify, have you been convicted of a crime, and if so, how many?
Yes, Your Honor, we believe the answer would be 12, with the first 3 coming from the state of Nevada, and then the remaining convictions all in the state of Wisconsin, mostly from Milwaukee County, but also 1 conviction from Wood County and 1 conviction from Manitowoc County.
So, Mr. Brooks, I'm not going to address this today. The state's putting you on notice that if you elect to testify in this case, they will be seeking a ruling on whether you may be asked, have you been convicted of a crime? And then the follow-up, if that answer is yes, is how many times?
I do want to just say one thing, and not to that. I just wanted to state one thing on the record, that I did inform the bailiffs that I did not wish to accept the paperwork that was brought up by the detective. I don't know his name, so I don't want to be disrespectful.
The information I have is Detective Ragland did personally serve you with that. He'll file the appropriate service if need be. Whether you take that paperwork with you or not back to your cell is your decision, sir.
Well, I just wanted to put that on record that I'm not accepting the paperwork.
Your objection to the paperwork is noted.
Yeah, and that doesn't matter. Like, the paperwork is there. You were served the papers. That means that you have them. Legally, you have them. You cannot claim later that, oh, I didn't know about that because I never received those documents. You have them. And you just stated that they were given to you. If you don't want to accept them, that's your choice. You will not have that information, but you cannot then go back and be like, I didn't know about it.
I did have another question about, in the event Mr. Brooks has forfeited his right to be present in the courtroom and has been removed, how will cross-examination proceed?
Well, I've reviewed the case law, and one of the possibilities is that he forfeit his right to cross-examine. If he's not in this courtroom, it's can be challenging to facilitate cross-exam. And if he's able to abide by the rules of decorum and civility, and whether it be even objections, right, or cross-exam, I mean, that can be shut down, for lack of a better way of saying it.
I understand that, and I know this court has been more than patient. We would just ask the court for continued patience. We want Mr. Brooks to be able to confront and cross-examine his accusers. He has demonstrated the 2 occasions so far that we've had testimony. He's quite efficient at asking questions, and so if he is calm and cooperating and not rude and disrespectful, we believe he should be given the opportunity after every witness to cross-examine. Even if he's in the other courtroom, we should at least make that inquiry, unless it becomes absolutely not an option because of his conduct.
I would agree.
Okay, thank you.
Yeah.
So
Ms.
just so I understand, 'cause I don't, how can I forfeit my right to actively and effectively participate in a trial if I have to constantly be put in a separate location? How will I be able to see everything that is going on in the courtroom? How will I be able to effectively put on a proper defense?
And this is the main thing that he wants to keep in the record for the appeal, that he was moved around the courtroom, so he wasn't able to put on a good defense. But the actions that he made throughout the trial made it impossible to continue. Like, it was ridiculous how long he was stalling, yelling, repeating, and so the judge had the option to just remove him and continue the trial without him. And since he doesn't have a lawyer, the trial would just continue, which would have been faster, but it would have not been the same. Let's just leave it at that.
Mr. Brooks, I direct your attention to Illinois versus Allen. That's the case that I've been relying upon regarding your removal. That's found at 90 Supreme Court 1057 from 1970.
Just so I understand, the Supreme Court, the federal court?
That is the Supreme Court of the United States of America.
Yeah.
Is that federal?
That is the Supreme Court of the United States of America, sir.
I'm just really seeking to understand, Your Honor.
Sir, that
Just Google it. Like, make a note on your notepad. Be like, I need to find out if the Supreme Court is federal. That I don't know if it is.
is
Don't
the Supreme.
understand, so
Sir, I've answered the question.
you have, but I still don't understand. That's why I'm asking the question. I'm not disputing it.
Sir, I'm not going to explain the law to you. I cannot do that.
I'm not asking you to.
Yes, you are.
I'm asking, is that a federal court?
All right, I'm going to move on to the next topic.
I still don't understand. How am I expected to do everything in a legal basis, in a legal manner and everything when I keep informing you, Your Honor, on record, in open court, that I did not understand, that I still have yet to understand the true nature and cause of the charges against me, which I don't understand.
It's not the judge problem that you don't understand. That doesn't matter to her. You decided by your own will to represent yourself. That would mean that you're prepared to do it. So if you don't understand something, that's on you. And it will always be on you. No one has the obligation to help you.
There's so many things that I do not understand that I keep explaining to you, Your Honor, that
Mr. Brooks, I'm going to refer you back to document number 244, which is the waiver of right to attorney form that you willingly, knowingly, intelligently, from my perspective, understandingly filled out. Let me make my ruling, sir. Do not interrupt, or you will be muted. All right?
Just mute me, Your Honor.
Okay.
So from my perspective, sir, we clearly went through not only this form, but really the topics that are referenced in this form, the advantages of having an attorney represent you, the disadvantages of representing yourself. I honored your request to represent yourself. And it's a bit disingenuous to now say you don't understand what you did. So we're going to keep going. I need to go through some other topics. You are not muted, but there's nothing for us to discuss at the moment.
I'm not trying to discuss anything.
And you see, he took out the headphones. He always says that he cannot hear well when he's on the other courtroom, but now he forgot about it because he's mad. When he's mad, he forgets about everything. He forgets about the pain. He forgets that he's tired. He forgets that he cannot hear. You see it right now. He's not tired anymore. He wants to argue.
Just letting you make the record, which I haven't been afforded the opportunity to make the record when I offered for my appeal.
We already talked about that. She already told you that this is not the place to do it. It was literally 5 minutes ago.
Again, I do not understand, and Your Honor, I think it's very unfair for you to say that you're finding that I understand. How can you tell me what I understand and what I don't understand? I've clearly made that very, very clear that I don't understand. And the same document that you referred to that I filled out specifically crossed out the word understand. Why did I do it like that? Because I do
All right,
not
Mr. Brooks,
understand.
I'm going to mute you because we're off topic. We've gone over this time and time again.
No, I did that earlier, but I was printing a bunch of things and then.
So put on the record, Madam Clerk, what you believe you provided to Mr.
It
Brooks
was a
already.
preliminary.
And again, referring to that document that he says that he crossed out stuff and changed stuff. In that document, it said that you cannot do any modifications to it. So he had to read that, and they pointed that out when he signed it.
All right, so he was provided with the packet of preliminary jury instructions. So let me I just need to add a line in here. I'll print this here for the state, and I'll print it in the other courtroom. There's a printer over there as soon as I do that. All right, I'm going to unmute Mr. Brooks.
See that? Now he physically touched the paper. Like they put him on his table, he touched it and then tossed it to the side. That means that she had those papers and decided to not use them. That's on him.
For now, I was not looking at the monitor because I was sending the email to my clerk with that document, but I just like to get confirmation at least it was put in front of him on the table.
And see how much of a child he is? Like, go back and watch how he's doing this with the chair. He's so desperate. He needs to be talking. He needs to be in control for him to be like at ease.
Whether he accepts it or not, I understand, but Mr. Brooks, was that piece of paper placed in front of you?
Yes.
I don't accept or consent to any paperwork.
Judge, I did see on the monitor the bailiff set some paperwork on the table in front of Mr. Brooks, and he took it off the table and set it on the floor next to him, it appeared.
All right, thank you for making that.
Accept or consent to that.
What do you mean that you don't consent to that? We all just saw you doing it. You're on camera. We can see what you do.
I will
Mr.
not
Brooks.
accept any more paperwork.
All right,
period.
Mr. Brooks, you've made clear you're not going to accept paperwork, but we have an obligation, whether you make that statement or not, to provide you with copies of everything the court is addressing with the parties. So what you do with them is up to you. So your objection is noted.
You may be aware that certain things are not going to be awarded, especially when it comes to fairness.
Mr. Brooks, I need to move on to the jury instructions. Are you willing to participate in this process right now?
No, I am not. And I don't give consent without me being present in the courtroom, like I said before I was brought over here.
They told you if you wanted to come back. We have on record. We just went through this, that if you wanted to come back, you can.
Would you like to come back over?
So why would you ask me now? Why would you ask me now?
Mr. Brooks, you were put over in that courtroom because of your disruptive behavior. If you can agree to abide by the rules of decorum and courtesy,
I'm not gonna
then
agree to
I will
anything.
bring you back over here at any point in time.
I'm
Did
not
you
gonna
hear me
agree to
advise
anything.
you of that, sir?
No, I did not.
She was responding to what she said, and then he didn't. He said, "I did not hear you." How can you respond to someone that you did something that you didn't hear?
You're advised, sir, that if you want to come back to this courtroom, you may make a request at any point in time. If you come back, the court expects you to follow the rules of decorum and courtesy that you've previously been advised about.
So is this how it's gonna be the whole trial?
Yes.
Every time I seek to understand
Mr. Brooks,
something
I'm
and ask a
offering you the
question.
opportunity to come back to this courtroom
I
to
just
participate
wanna know, 'cause
here.
I don't want to go over there and then essentially have to come back right over here, because when I ask something that I don't understand, it's being looked at as me intentionally trying to disrupt the court.
Mr. Brooks, I'm
sure-
asking you a question. Please
I'll ask
answer.
you a question.
Would
I'll ask
you-
you a question as well, Your Honor.
Would you like to
I'll
come
ask you a
back to
question
the
as well.
main courtroom right now? Yes or no?
I've asked you a question too, Your Honor.
That's a
I've
no.
asked,
All right,
is
I'm
this
going to
gonna be
mute
how it's
him.
gonna go?
I'm going to make a finding that his decision to not answer the court with a yes or no is non-responsive. Attorney Opper, will you or Attorney Basie be addressing the preliminary jury instructions?
I will, Your Honor.
All right, do you acknowledge receipt of those?
Yes.
All right, I will put on the record that the 68 pages were also provided to Mr. Brooks. What I intend to do is to read the following. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I understand Mr. Brooks is objecting. I'll give him an opportunity to make any statements regarding that. On the record, I'll ask the state first whether there's any objection to inserting this in that location.
No objection to it. Inserting that, I would just note that in all of the jury instructions, I don't think we've ever mentioned Mr. Brooks by name. I think it's always been the defendant. I don't know if the court wants to be consistent. That was my only comment.
I think it would be good to be consistent. Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Yeah, first of all, I'd like to state for the record that I'm pro per, not pro se.
It's the same. It's the same. It literally means the same. Like, it's Latin. No one knows. Everyone knows what it means by now. And proper and pro se is the same thing. It doesn't have any difference other than the word.
And what you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location?
Because you are you've been Because you're in the other courtroom. This is a new thing. This does not happen often. I mean, I'm sure it's happened in the past and again in the future, but for this situation, it needs to be added.
If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
That's not what they mean.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object, consent, agree, or otherwise?
No, I don't consent.
That's not what she
I do
asked.
not.
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to
You
the
just
whole,
said so yourself. You just said so yourself. They need to be consistent. So why does anything need to be changed at this point?
Because it needs to be consistent on the paper that we're having. And the paper, the thing that we're talking about right now.
I also want to make
Small D.
state this on the record. You just referenced wanting to protect my rights, correct?
you have the language in front of you, sir?
Well, you just said on record that you will want to preserve my rights.
Mr. Brooks, you have the language of the jury instruction immediately on the screen in front of you. Do you have a question or a position on whether that's included?
I was getting to that. You did not let me finish.
Get to that then.
So it's not a question. Like I said, I was stating for the record. Part of protecting my rights would be the ability for me to inform the jury of the truth, their rights, and their duties under the First and Sixth Amendment.
Do you have a jury instruction that you would like me to read that would state that? Have you drafted anything, sir?
I wouldn't need to draft anything if it's already in the Constitution.
Nah, he doesn't understand how the Constitution works. He doesn't understand how a trial works. And here he is trying to plant the seeds for him to argue for jury nullification at the end. So this is what he wants at the end. He wants to, his goal was to try to get enough doubt on the jury for them to be on his side and nullify the trial.
I should be able to be afforded for those rights to be protected under the First and Sixth Amendment.
I'm sorry, I mistook what you were saying. I thought you wanted me to add a jury instruction, a written jury instruction, so that I would read something to the jurors. Am I mistaken on that?
It's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for Your Honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
Why not give why not give her a written statement from the beginning if you already know what you want to do?
For the record, also may I state, and it's going back to the language that says pro se. Can that be changed to pro per?
No.
That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions.
Part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that
the ability to
accurately
have
states.
that right preserved?
I do not believe that statement accurately reflects the law. All right, so we'll make Mr. Brooks, I'm moving on.
Can you show me by
Mr. Brooks, I'm going to mute you. Does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question, actually two. Do you have any, and you're raising the objection, hold on, you're raising the objection sign, it's noted for the
I'm
record.
gonna continue doing it, that's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for
just said
edits? Let
what
me
my
finish the
request
question,
was,
sir.
that I have
You're
a
interrupt,
problem with-
all right, I'm gonna have to mute him again so that
Yes.
I can get my question out. Mr. Brooks, my question to you, do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I will be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am
That would be
addressing
some
what
time.
we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yes, no?
Yeah,
No.
you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties. That
Sir,
that they have.
I have provided an answer to that.
Trying to finish.
All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding.
Yeah.
It's a non-response type of answer. As to what we specifically have before us today, do you have any objection?
Yes, I do.
What is it?
Okay?
What prompted the change now, all of a sudden?
Because this is the time in the proceedings for the court to finalize those and to address any modifications. That's standard protocol.
Yeah, there you go.
So I'm still,
All right, your objection is noted, sir. I am approving everything that's in there. Mr. Brooks will still have an opportunity to submit any additional proposed instructions tomorrow morning, but at least we have this packet that's been approved.
All right.
The
With that, we finished the pre-trial. Thank you for watching. I'll see you guys tomorrow with the next episode of the proper day one of trial. As always, the link to the videos in the description below. Have a great day. Bye-bye.